was the president of the Virginia State Bar, June 2013 through June 2014, and is the past president of the Fairfax Law Foundation and a past president of the Fairfax Bar Association.
I'm tired of it.
Okay. Mr. Simek is the vice president of Sensei Enterprises. He has a national reputation as a digital forensic technologist and has testified as an expert witness throughout the United States. He holds a degree in engineering from the United States Merchant Marine Academy and an MBA in finance from St. Joseph's University. He holds a prestigious certified information systems security professional and in-case certified examiner certification.
That's good.
Yeah, our bios go on forever. We actually have a short form bio, which obviously they didn't send you.
They did not. Well,
next time you'll know to ask.
they are highly qualified to give this presentation today. Please give a warm welcome.
Thank you, and I'm sorry for those of you who are in DC that you cannot see the screen. Look at that. Will you allow? I guess.
Yes.
Yes. Sorry.
Somebody has to.
Thank you. Okay. All right. So whoa.
It's Sharon. It takes a second to connect.
Okay. All right.
Takes a second to Sharon to care.
It'll shift with the basic color desktop.
Yeah. Your questions are welcome at any time, so feel free to ask away. This presentation has been updated over the course of the last 2 weeks. It's extraordinarily current, so even if you've seen some version of
Up
it.
until this morning.
Right up until this morning when we drove our host crazy by saying we made more updates, here's the new version. But that's okay. The cover that you saw there was the ABA Journal, and Dewey LaBeouf is the firm in New York that went under, and the roses they put on their faces because the lawyers had painted such a rosy picture of the finances of the firm, and as you will learn later when we talk about the case, the rosiness was really nothing that was real. The jury has that case now, and they have not come back as of this morning.
Woman with ring.
Shut up, I have to figure it out because it doesn't, the error doesn't show. This was we're married, which is what that would explain. Normally presenters don't talk like that. But they call us
High maintenance, right, Chris?
they call us at one of the John and Sharon shows.
Thank you.
No commercial So there you go. Okay, this was the title of an article I saw recently. Luddite lawyers are ethical violations waiting to happen. And I certainly think that's true. You got a little flavor of that listening to Kristin when she was talking about you really have to understand the implications of social media. You just can't blunder off and do whatever you want. So this is Rule 1.1 and 1.6. Rule 1.1, they changed the comment at the ABA level and said a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. That has now been adopted in 14 states. Has it been adopted in Virginia? Not yet. In June, the Virginia State Bar Council passed the, not entirely the whole thing, but most of it. And I'll tell you what they didn't pass because it's funny. It's funny. So we've done it. We sent it to the Supreme Court back in June. I know they met in August, but we have not heard back from the Supreme Court whether they're going to adopt that version or whether they have any questions they want to ask us. These are the 14 states that have adopted Comment H Rule 1.1. I thank my friend John Trudenik from Catalyst who allowed me to use his chart here that shows you the 14 states. So we might be on this map almost any day, but we're not there yet. Now Model Rule 1.6, they changed the rule itself, saying that a lawyer shall make reasonable efforts to prevent the unintended disclosure of or unauthorized access to information relating to the representation of a client. Clearly the problem there is the word reasonable efforts. What does that mean? It involves the sensitivity of the information. As for instance, you are never ever going to see the formula for Coca-Cola transmitted over email. That is just simply not going to happen. One of the factors is the likelihood that it will be disclosed if there are not additional safeguards. So important information, you might need more safeguards. The cost of employing the safeguards. So the big firms are going to be held to a standard standard way up here. Venable's going to be held to a very high standard. The solos and the smalls, the costs in some cases are much too much for them. Or it's perhaps the difficulty of implementing the safeguards, although the safeguards have gotten infinitely easier and less costly over time. And does it have any adverse effect on the lawyer's ability to represent the client? What I mean by that is, suppose you want to put security software over here, but it doesn't get along with case management software over there. So if you've got some kind of issue like that, that would be another factor as well. Now, a client may require more security. That's the ABA version. We took this out in Virginia. Probably those of us who were the officers, I was then the immediate past president, and Kevin Martingale, then the president, he whispered to me, "These guys don't want this. What's wrong with them? You want to talk to them?" And I said, "Kevin, if the client demands more and they won't give it, the client's going to walk out the door." I said, "It doesn't matter." So I didn't fight it, but that's what the council did. They said that the client may not require more, that language is gone, but they will walk. And the reason we find law firms, just ramping up in security is because clients are demanding it, and clients are saying, "You've got to pass this security audit," and they don't even understand the questions of the audit. That's a problem. So we are finding client demand for encryption. That's driving the law firms. They don't have a choice. If they want the business, they've got to do it. Now, it doesn't address any legal or regulatory duties, so that's all outside of this. And when transmitting a communication that includes information relating to the representation of a client, the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. These days, that often means that email, which no one believes is private anymore, email must be encrypted in reasonable circumstances, appropriate circumstances. California has become the first state to require competence in e-discovery. That really was quite a firestorm on the legal blogs. They did this just in June of this year, and they said, look, if you can't learn it, if you're not competent, then you need to acquire the skills that are needed. You need to find, yeah, this is the new one, thank you, because I see my misspelling has been corrected. You need to find some skilled lawyer or expert assistance, or you have to decline the representation. Now that's pretty stark. You got to decline it if you don't do one of those things. And lack of competence may lead to a violation of Rule 1.6. So very interesting. So I'm not going to read this screen, but you're going to hear stories. The stories of the bad boys and bad girls of law are wonderful. That's what everybody comes for, and I guarantee you, you will go home tonight and you will be telling stories, because you're not going to believe what the speakers told us today in our ethics session, because some of the stories are great. Now, we have to go through all the ethics slides first, because that's part of the
None of the
drill.
stories are made up.
No, you couldn't make them up. You absolutely couldn't make them up. Do you guys see us now? Yes? Okay, all right, we're back on track. Just wanted to make sure you could see. So the list of our misdeeds is very, very long, and we have actually come into some of this. We have had lawyers come to Sensei, which does digital forensics, cybersecurity, and information technology, and we've had lawyers come in, and they've been very candid about the fact that they're shopping for experts, and they want to find an expert that they can spin. Now, is that ethical? Of course it's not. And so I politely show them where the door is and explain that they have come to the wrong location. But that's something that lawyers routinely do, is look for experts that they can spin.
So what should you guys be doing, right? Exactly what you're doing now. Get educated in CLEs, because this stuff is changing rapidly, right? We've seen more changes in the law in the last decade than we have in the last couple hundred years. So make sure that you're maintaining your competence, that your assistants are, and if not, as Sharon said, get some help. Know what you don't know, and when you're outside your league. So, our first story. This is August of this year in Queens. See there, this is an actual tour bus was swerving to miss the car, smashed into this law firm. Small law firm, nobody was hurt, nobody was there. The problem, however, though, are you ethically required to make sure, certainly, that your data is safe? What if they got nothing but a bunch of paper stuff? So now we got a fire in there, boom, stuff's gone. Or electronic, do they have offsite backup here? These are the kinds of things that you need to think about. So if you get into a catastrophe like this, you're ethically required to properly represent your client. So if you don't have a backup offsite, what are you going to do about that? Are you going to miss a court deadline? How are you going to deal with all that stuff?
Cyber insurance is good risk management, but they don't cover stupid. And this was a real case very recently in July. It didn't involve a law firm, but boy, it made all the legal blogs and everybody was talking about it. Most people don't know whether they have cyber insurance. Most people don't know whether their firm does, and most people don't know what it covers. So you see, I love Albert Einstein's quote there. Two things that are infinite, the universe and human stupidity, and I'm not so sure about the universe. Well, when I read this case, I went, that's just the perfect quote. What happened here, and it was reported in July of this year, Cottage Health System had a breach in 2013, and they said, oh, but that's okay, we're insured. But the insurer refused to pay because the policy required minimum required practices, and they said they hadn't done it. Now, John's going to tell you what they didn't do, but I just want to point out as a Star Trek fan, that's a double face palm. So that's when one face palm isn't enough. You both got to plant your hand. There you go.
So these are some of the things that they didn't do. So they didn't properly configure their IT systems. They didn't have proper regular patch management. In other words, they weren't installing updates, right? There's a reason why vendors release updates, so that you can apply them and then make your system secure, because a vulnerability's been discovered. They didn't do that. They frequently didn't analyze their systems, what their risk factors are they subject to attack, et cetera, any of those kinds of things. When they were breached, their data was exposed on the internet for about 2 months, is what they figured. The data was in clear text. It wasn't encrypted. They had no systems in place to identify or monitor or even log the attempts to access the data that's there. Since the data was in clear text, and we've actually had another real case where you could just Google it. So the Google robots are climbing all around the internet as you know it, indexing all this data. So if it's in clear text and it's not encrypted, you just do a search, it's exposed. Boom, pops right up there. So that's why they didn't cover stupid.
And a lot of law firms took note of that and started saying, what are the minimum required practices under our insurance policy, which nobody really reads. They have a cybersecurity rider, and nobody understands the rider. Or these days, it could be integrated in the policy. They don't understand that either. So somebody at everybody's law firm better be looking at that. Another non-law firm case, but an amazing one, which is going to impact law firms, just happened in August with Wyndham Hotel Group. They had 3 breaches, and the FTC said enough. They said that they had the power to bring enforcement actions against businesses that failed to take reasonable steps to prevent breaches. And they have filed more than 50 actions so far. Do we have law firms that have been breached multiple times? Heck yes. Could they come after them? Heck yes. So that is something that is also worrying law firms. Kia Motors, which, as you see the tagline, they have the power to surprise. Well, they surprised some of their lawyers and some people who wanted to be their lawyers. They audited 9 firms and their associates, and all 9 failed in the audit. Now, some of the firms were simply not hired, but those who stayed working for Kia, they had to agree to a 5% price reduction until they could pass the audit, which was an audit of legal technology skills. So what couldn't they do? They couldn't do the basic functions of Word and Excel. That's pretty amazing to me. I mean, going to law school, they don't teach anything about this, and apparently not. They would, to print the PDF, they would print out the document, and then they would take it to the scanner. You know, the print to PDF button is so much easier, right? Excel sort and filter.
I get through the metadata that way.
Yeah. Excel sort and filter. It should have taken them 20 minutes to generate from a spreadsheet list a list of exhibits associated with witnesses on specific topics. It took 5.5 hours on average. Now you just figure the billing rates there, and that is unconscionable that they don't have these basic skills. And they were brute forcing PDF by PDF by PDF because they didn't how to batch search. Now that's crazy. It's just insane. What are they teaching in law school? That's the first thing that Casey Flaherty from Kia asked, and others as well have asked the same question. And one of the answers was given by a law student who said, well, you know, if they had Facebook and Instagram as courses in law school, I would have gotten an A, and my parents would have been so proud. And I thought, well, you know, that's sad, but there's probably some folks like
The
that.
scary part about this whole thing that Casey Flaherty did was these were senior associates he tested.
Yeah, senior associates.
Not the junior associates,
And
not the partners.
And you know what, he didn't test the partners because he didn't want to humiliate them. So I thought that was an interesting way of answering it. Now, this is our friend who is now Dean Andy Perlman. He was a professor. He just became dean at Suffolk University School of Law. You can see by the Google Glass that he's kind of a geeky guy. He is brilliant. He actually has his students text him questions which appear. We liked Andy instantly when we met him, which is a line from Shawshank Redemption, I believe.
I did question Andy on the wisdom of giving his students his cell phone number, but
Yes, he certainly did. Well, Andy hooked up with Casey Flaherty from Kia, and what they have done is automated the audit, which is online, and it is the Suffolk Flaherty Legal Tech Audit, and you can go on and you can find more about it. We are telling folks that this is a real differentiator. If you can say you passed this audit, you're looking for a job. But what it's being used for primarily right now is it's being used by general counsels and corporations. You know, they have that more for less is their value proposition now. So they're testing to make sure they're getting value for their dollars. So they are insisting that the people who work on their cases be able to pass this audit and that they get proof of it. Pretty interesting stuff.
so let's move into Bitcoins. Everybody know what Bitcoins are, right? Anybody traded Bitcoins? We have one brave soul. Hey, do you know the difference between the Bitcoin network and the physical currency? How you tell? The network uses a capital B. That's the infrastructure of the Bitcoin network. The lowercase b is the actual currency itself. So what is Bitcoin? Well, Bitcoin is cryptocurrency. It's electronic, it's worldwide, it's distributed on a peer-to-peer network. Every single node on that network knows about Bitcoins. And it's the ledger, so they know that if there's a transfer at one point, then the ledger gets updated. So all these transactions run around there. It's based upon the demand. The value is based upon supply and demand of Bitcoins that are there. It was first started in 2008 and then became open source software in 2009. So it's still relatively young. There's several other cryptocurrencies that are out there, virtual currencies they call them as well. But it's probably the most popular of them all. Today, one Bitcoin is worth $236 US. Back in November of 2014, it was 427. In January of this year, it was down to 177. So you can already see how volatile the Bitcoin movement is.
And that's one reason why the ethics of this is that if a law firm decides to accept Bitcoin, the ethics is that you should probably convert it instantly to real money.
We'll talk about that.
Okay.
It's primarily used by criminals, bad guys, or criminal defense attorneys, because that's their clients are the criminals, and they want to trade in Bitcoins. That's primarily where we see that. Or if you're trying to hide money from your spouse, as well.
We see it in family law.
Family law, we
cases.
see that, yeah. So,
I'm sorry. I'm asked.
she knows again. So do lawyers accept Bitcoins? Well, yeah, more and more are accepting it. Back in February, there's a law firm in Virginia, was thought to be the first one in Virginia to accept Bitcoins. They're an estate planning firm. They use a service called Coinbase, that's based out of California. What you need to do is Bitcoins are held in an electronic wallet, an encrypted electronic wallet. So they don't do you any good unless you can actually convert them into something else or trade, almost like in a barter system, trade a Bitcoin to somebody else for some service or product, right? On the dark web, that's how a lot of the illegal drugs and those kinds of things and child pornography purchases, unfortunately, they trade Bitcoins, they'll transfer a Bitcoin, a certain amount into the person's wallet, electronic wallet, and then they get shipped or sent, the contraband. Coinbase is an actual financial institution. that does the translation of Bitcoin to dollars, or Bitcoin to whatever currency. So there are services that are out there that will do this kind of thing, this transition that's there. There's more and more now lawyers that are actually accepting Bitcoins that are there. This particular law firm is considering, they haven't had a client yet that's actually attempted paying Bitcoin, but they're considering keeping some of the money transferred into Bitcoin as really almost like a financial hedge, if you will. So if, depending on what the Bitcoin is, like day trading, right? So depending on what the market's looking like, they're thinking of savings, keeping some there.
Mr. McCauley and Bar Counsel is not gonna think that's a good idea, because in the United States, Bitcoin is property. So you wanna convert that property to a value that's recognizable right away. And so he's not gonna like that idea.
Well, even though talking is part of it. But the other reason that folks are liking Bitcoins is there's no financial transaction amount that goes along with it, unlike a credit card fee or processing fee or those kinds of things. So there isn't any fee, if you will, to deal with these Bitcoin transactions. Any other questions?
I was just going to ask you, are the retainers in dollars or?
Yeah, you have to do it. Yeah.
Have they agreed the fee and then they hope what the Bitcoin will be, or is it?
Well, if you're going to hold on to them, the criminal defense attorneys that we're aware of that do currently accept Bitcoins from their clients, they convert them immediately. So in other words, they tell
also bet in dollars.
Exactly. They say, okay, your retainer is $5,000. That's today. That's the equivalent of X amount of Bitcoins.
So that's what you owe.
Yeah.
And it's an immediate transfer, and you accounted for it in an appropriate way. That's actually Sharon in England is a entertainment law firm. I just thought that was an interesting photo that they chose to have on their homepage, and they also accept Bitcoin. But we still find it mostly in criminal law.
Right. Now,
Can a law firm's private investigator use hackers for hire? What's your best guess? No. It's a crime to hire somebody in order to do that.
to do something illegal?
But this is from March of this year, and there was a PI in New York who pled guilty to stealing email credentials using hackers for hire. The crime is conspiracy to commit computer hacking, and he said he was working for 20 law firms at the time. 20 law firms is a whole lot of people doing something they should not do. And this shows you the amount of money he had to pay per account hacked, $50 to $250. He was sentenced to 90 days and 3 years probation, $1,000 fine, and they are now looking for the law firms, the ethics people. So that's not going to go well for them if they find him. So these are the real life stories of the lawyers who had to say my bad. The bad girls and boys of law.
So the first one comes out of Connecticut. It's Kristin Chilton. And you'll see here that the discipline board found him to there was probable cause. He was preparing a sham contract. And these are the bottom two bullets here are the two ethics violations that they found him in violation of. Basically what he did was, an ex-governor, they thought it would be a great idea if he worked on this re-election campaign of somebody else, just because of what he knew, his contacts and all that kind of stuff. But if the ex-governor was on the election campaign, he would be doing so unethically. So they couldn't hire him. So Mr. Sheridan thought, well, that's okay. I'll hire him. And then they pay me, and then he doesn't work. So this whole thing on there, his defense was that he didn't know that it was illicit for this ex-governor to be able to work on this. But it all came to light because with elections, you have to disclose where your money's going, where it's coming in, where it's going out.
Do notice it says alleged.
Alleged.
We'll tell you when they actually have been disciplined. So this is one who was Yarborough Sully. I may not be pronouncing her name right. She was suspended for a year beginning in July. That was affirmed by the Supreme Court in August. She charged a client for watching crime shows on television. In fact, she charged the client over $5,000. And in the first 3 months of her representation, she charged $140,000. Now they looked at what she had done. She had filed the suit, a wrongful death suit, and she had gathered a few records, and for that she charged $140,000. She blew right through her entire original estimate. She was completely unrepentant. She said, did she say? Since when is watching television not reasonable for legal research?
Isn't that how the courtroom works? Law and order, it's the same way, right? Just like CSI is right.
So, you know, don't, and in her case, she not only charged for watching all these episodes of 48 Hours, she charged for watching them again. That's balls. That's balls, not sense, but balls. Okay, so this is Dennis Mullen, who got 1 year probation in anger management. He originally agreed to a disposition, but in September 1st, the story came out that he was asking it to be set aside. So he's using email. You notice all this is digital stuff that we could get in trouble, and you won't find us using cases here that's old-fashioned trouble. This is the trouble that has to do with the digital error. So he called the client a cheap so-and-so, and you can see all the asterisks and figure out the word, and threat to sue. And later he said, okay, drug dealer, I look forward to the many nights and mornings when you think of me, think of my name and squeal. You mean nothing to me. Check out the movie Deliverance. Now that's just not a smart email.
It's a great movie though.
And everybody knows, if they've seen the movie, they know exactly what he's referencing. So this was not smart, but he is in fact asking to be set aside. This is Michael Jerome Moore. This is not Michael Jerome Moore in this case. This is a stock photo. But I tried to find a picture of him. I looked. I try all the time. He is a Chicago attorney, and there was a complaint filed in August of 2015. So this is not settled yet. He apparently left abusive voicemails. All black people are alike. You're slovenly, ignorant, low class, the N-word. He's a charming man. I'm going to have you all locked up. And to a different person entirely, he called him a stupid Jew. You can see what. So the complaint understandably alleges offensive conduct, neglect of criminal appeal, and failure to comply with document requests. The offensive conduct is what I've got here. He told the press that the whole investigation was ridiculousness. Probably not a good legal word choice either, but that's what he said, and God bless, I don't know. He's obviously got a problem.
We have cyberbullying prosecutors as well, right? So it happens on both sides, whether it's the defense side or the prosecutor side here. And this is from August of this year. The Fifth Circuit Court of Appeals affirmed the lower court's decision. These are 5 police officers out of New Orleans, where 5 police officers are going to get a new trial. Because what happened here is that 3 of the government lawyers started posting anonymous comments about these police officers. And the other problem that they had was that the prosecutors had cooperating defendants that were testifying, and they all lied. So they've got these lying defendants, they got these government attorneys that are posting comments up there trying to sway the jury into all these decisions. And as you can see there, I'm not going to read them all, but you know, basically deprived these police officers of a fair trial.
I'd like to say in the Virginia State Bar, you are occasionally going to read Virginia Lawyers Weekly that we favor prosecutors and don't go after them in disciplinary matters. You're going to hear that we don't go after criminal defense counsel. Garbage. We go after both of them whenever it's warranted. But each one will say that about the other side, which is hysterical because there's so many cases on both sides of the line. Anyhow, I'm just defending my bar. In August 2015, we had a case of egregious attorney misconduct. This was Karen Bellotti, a lawyer for the California Department of Transportation. She got way over the line. She defeated a claim by a motorist against the state after a crash on a very complex road interchange. We're not talking a little bit complex. We're talking, it made the Guinness Book of World Records as the most complex interchange. So it really was a problem. The 4th Appellate District reversed on the case because she ignored a string of motions in limine and repeatedly asked questions after the judge had sustained objections to the question. Why the trial judge allowed it, I don't know. He had the patience of Job, but the patience of Job when somebody is not supposed to be doing it.
It's California.
It is California. I know.
Wacko.
I once quoted a California case in an argument, and the judge said, "California, what else you got?" So I learned, not the Virginia court. Okay, so do you know Godwin's Law? Anybody here know it? Oh, then I've been around a little longer than you guys, so I'm going to teach you something today. Godwin's Law says, the first side in an argument to compare the other side to Hitler or the Nazis loses. You can look this up at Wikipedia, which is important.
You're not going to cite Wikipedia, are you?
It's everywhere else.
Come on.
You will actually find it in legal cases. But Bellotti violated the law just a ton of times, just gratuitously saying things about him being a Nazi, and you know, he wore a helmet that looks like what they used to call, let's see, you wouldn't know any of this, but in World War II, they used to call it a Fritz helmet because it looked like a World War II German soldier's helmet. No, this one doesn't have a spike. Yeah, that was World War I. So she kept referring to this kind of stuff over and over and over again. It was absolutely absurd. So the judge, sua sponte, referred the matter to the California State Bar. Now, if you're wondering if judges refer complaints to the Virginia State Bar, yeah, all the time. All the time the judges will turn lawyers in. So remember who has the power when you're in that courtroom. And if the judge tells you to sit down, it's a real good idea to sit down. And if the judge doesn't like your question and you know, sustains an objection, don't ask the question again. I mean, judges hold the power. So, there we go.
This one from Nevada, just August of this year as well. This is really a sad case. This attorney was faking the records that clients had completed court-ordered counseling and community service in 91 cases. Now, once he got found out, and here's where the really sad part is, he actually considered killing himself, sat in the closet with a gun, a loaded gun, and thought, how should I get out of this? His wife actually attempted suicide when he did all this. He's been recommended a 5-year suspension. There's the disciplinary panel. The kicker here is, before he can request reinstatement, the panel said he has to retake the bar exam. That's major stuff. This is another sad case. Louisiana Supreme Court disbarred this woman, this attorney. She went off on a social media blitz. What happened was a friend of hers was having a divorce and custody issue in Mississippi, right next door. And the judge didn't rule favorably, I guess, for her friend. And so she thought it was really stupid what the judge did. So she went off on this and created 2 change.org petitions, started putting blog posts and things up there. Basically, and those are some of the quotes of things that she posted up there, but essentially trying to sway the public because the judges in Mississippi are elected. So that's what she was trying to do. She's basically putting words up there like, don't reappoint these people, all that. Well, the disciplinary board didn't think that was a really good idea.
But you know, a lot of times, if you're before a disciplinary panel, and I hope never to see any of you there, but the fact that you display a lack of remorse or a defiant attitude, that kills you. Because the moment you say, I'm sorry, I'm going to get help, I have a substance abuse problem, I have depression, I know I need counseling, I'm going to go to lawyers helping lawyers, the minute you say, I know I did something unethical and wrong, and I want to fix this, please help me understand how, you're going to get a much more lenient outlook than if you go in there with a defiant attitude and you tell lies and you don't show up. Remember, we had one guy who said he spent 2 hours driving around Richmond and he couldn't find the bar. It's pretty hard to drive circles around Richmond for 2 hours and not be able to find the bar. He just didn't want to come because he didn't want to deal with the situation.
When he missed the,
yeah,
yes.
When he missed his own hearing. You don't. That's another thing. If you have a hearing and you're named to come to the hearing and you're under process to come to the hearing, show up. Show up, first rule. Okay, I've been watching Lee Mullen for a while. He's been in the news for a while. He was this year suspended for 1 year for faking more than $69,000 in cab expenses. He was suspended by the Illinois Supreme Court and it required him to have 1 year of psychiatric treatment. Now there were an additional $379,000 of expenses questioned and he paid the firm a total of $400,000. What I thought was hysterical was that he moved, when all of this was public, he moved over to DLA Piper, who knew about all this, and they hired him. All this stuff had been in the press, and they hired him anyway. But he left the DLA Piper when they knew that the Supreme Court order was coming. The other thing I thought, that Lee didn't get too well, is when he was asked about why he did this, especially the cab expenses. He said, oh, they're all legitimate expenses, but filling out the real forms with the appropriate information was too hard.
It's like robbing a bank until they fill out the forms.
The good positive, right?
Yeah, it just didn't make it. The argument just didn't cut it. Here we have Christopher Hollander, who was suspended by the Indiana Supreme Court for a year. He's a public defender. He texted a prostitute. He had found, if I recall, he had found an online ad for escort services. And so he dialed the phone number. This is always a mistake. This is always a mistake. And that phone was at the time in police custody. But they said, okay. He got the prostitute at one point, and he offered to help with charges against her and to work with her on the fees. So now he's being set up with a police officer impersonating a client, and when that police officer, I forgot officer, tried to hug and kiss, yeah, I know this one, tried to hug and kiss her, and he indicated that he wanted sex in exchange for legal services. Let me tell you that this never goes well, and we see it a lot. They text this stuff, they do it in person in their setup, they email, it's just absurd. Sexting, oh, well, isn't that next? Yes. Thank you, good segue. This is Jeffrey Hollis. He was disbarred by the Maryland Court of Appeals this year. You see what I mean? We throw out most of the old stories, and we try to show you that this happens all the time, everywhere. He sexted an unrepresented opposing party, offered to find a sugar daddy who would pay to watch her perform sexual acts. The court, unsurprisingly, found this prejudicial to the administration of justice, and they looked back at his history. He already had one suspension for sexting, and then he had another suspension for trading a painkiller for oral sex. So, this guy was establishing quite a record with the disciplinary folks in Maryland. So he can think about that for a while, well, for a long time since he's been disbarred.
So let's move up the coast a little bit, up to New York. Bronx Defenders is a legal aid group up in New York. They actually have a contract with New York City to represent the indigent clients and those types of things, and in family matters. That contract is worth $20 million. So these two attorneys that are named up there ended up resigning. They appeared in a rap video. Now what happened here is that the girlfriend of the video producer also was one of the Bronx Defenders and asked these two attorneys to participate in this video shoot. So they went through all this stuff, and they had, the attorney's response was that they thought that they would have an opportunity to edit the script and those kinds of things, but what ended up happening was the lyrics were very offensive. It actually encouraged violence against the police, and so under pressure they ended up just running out of the whole thing.
This is a prosecutor again. January of this year, he was charged with voyeurism. Apparently, this woman is sitting there in the tanning booth, and she's lying down, and she sees this ad come over the top of the wall, and there's a cell phone, and he's recording her, and she starts screaming. And of course, this is just the kind of thing a lawyer wants to do, knowing that you're walking into a place that has cameras, security cameras. You had to sign in. He signed his name. Here I am, and I intend to shoot photos of women tanning. It's just crazy.
Remember that don't be stupid thing?
Yeah, so I don't know the outcome of this case, did not forget, but don't ever forget video. That'll come up again too.
This one here in January of this year, again we have another prosecutor where the PowerPoint, and I just can't believe that the gentleman that was being charged here for the prosecutor's murder conviction was ended up being overturned. That because of all of these types of things. I mean, the defamatory things that he put up there in his closing argument in his PowerPoint. So he had 250 slides out of a PowerPoint for a closing argument. Does that take, what, 3 days or something to go through that? I don't know, but that's a boatload of slides. But 100 of those slides had headlines on it that talked about the guy, Defendant Walker, guilty of premeditated murder. And the words guilty were over the, oh yeah, you know, flashing right up
Yeah,
there.
they flash,
It's
guilty,
like,
guilty, guilty.
like, give me a break, dude. He had one slide where there was a picture of him eating dinner with his family in the Red Lobster, and the prosecutor's allegation was that, well, he's spending all this money because he robbed these guys. So he got this money, and now he's flirting it off and buying dinners and doing all of that stuff.
All stuff that had not been introduced within
Yes.
the closing argument.
Yeah, it's crazy stuff.
All right, now this guy does not look like the sharpest tool in the shed. He just doesn't. I don't know if you have the same visceral reaction that I do. But he resigned this year from the bar. He please.
Is that really his picture?
Yeah. Like I said, I mean, she even took his picture. Look, she snapped it. Yeah, that's hysterical. I'm not going to ask why. So he pled no contest to the misdemeanor charges of marijuana and obscene material distribution. He got 2 one-year suspended sentences. He said, again, gentlemen, something you never want to do. Do not send photos of your stuff to clients. I mean, that's junk. Yeah, our boys call him junk. So then he texted her. He wanted a threesome with her daughter, and the daughter was 13 years old. Yeah. So the police took over the phone again. Does this have a slight echo? You've heard this before. They took over the phone as the mother, and the mother, which is the police officer, asked if he would drop the legal fee if they complied. And he said, "Of course." So things people do. Now that's a lawyer. That is a
What's
lawyer
wrong with
from
it?
Winston-Salem. Well, you know, that's a very good question, John. I sent this to Jim McCauley, and I said, Jim, he's near naked, he's all oiled up, spritzed up. I said, you know, you got a problem
Did
with
this get
this?
through the bar's filter?
Well, this is in our state.
Oh, okay.
This is Winston-Salem. This is not our state. But I said, would he have a problem in Virginia? And Jim just shook his head sadly, and he said, no, we don't discipline for tacky. So that's what he said about that one.
That was like the car with the advertisement.
That's right. He said the same thing about, car advertisements. This is Corey Fettman. She's a Chicago matrimonial lawyer. Her website calls her incredibly talented and beautiful. And she was briefly employed by Playboy as the love lawyer, columnist. I love that name. She had a huge billboard that said, "Life's short, get a divorce." Well, some very zealous.
We saw that.
Yeah, I know we did. It did stop you. I mean, it did stop you. You had to look and read the
That was before Ashley Madison, too.
Yes, it was. It was before Ashley Madison. Yeah, we do a whole thing on the dark web and Ashley Madison and all that. Anyhow, this was taken down by a very zealous alderman who was deeply offended by it. So Corey, not to be outdone by any city alderman, she now put this on trucks all around the city and buses all around the city. So to this day, you will go to Chicago and potentially see her trucks and signs and all this stuff. So it's still there. Now, she also has on her website a gallery. She has some interesting, that word is in quote, photos. If you want to check it out, do so, but don't check it out at work. I don't know.
Use your neighbor's computer.
Yeah, you know, this is apparently okay by the authorities in Chicago and Illinois, and it reminded me very much of Elliot Ness in The Untouchables when he says, "Well, you're not from Chicago," and I guess not. I think this one might have gone over the top for Virginia. And that didn't, this one would. Adam Raposa has been up against the disciplinary folks in Texas for years now. In 2014, he put out this video, and what he's doing, which is a little hard to see here, but there's a woman in the back, she's got massage oil, she keeps dumping it on him, and he keeps rubbing himself while he's talking to the disciplinary folks in
Well, you can
Texas.
see the drop cloth. You don't want to get on the bedspread.
Apparently he's very thoughtful. I don't know where he is, maybe that's his office, who knows, if it's a hotel, probably more likely, but anyhow. So this video goes on for some time. This is another one I wouldn't suggest watching at work. It's creepy, it's downright creepy. But he's on the phone with the bar folks, which made it really interesting to the bar folks, who did not know, of course, that all this was being recorded. He's had many encounters with them. And his most recent one was March of this year, when he made a profanity-laced video, and you can see what he said there. But he printed up all these buttons, not buttons, what do you call it, stickers, that said exclusively for white people. And he posted them on stores that he thought catered to white people and not to other people. So he was constantly going around putting these stickers up, and they were constantly having to take them down. He looks a little skinnier there. It's not a terribly clear photo. He lost some weight anyway out of the whole mess. But this made the papers again. The disciplinary people were called again. I don't know why they can't do anything with him, but he is just a character. Well, he calls himself bulletproof, and says he has balls of steel. I think he has rocks in head, but that's okay. He was 90 days in jail once. I'm not going to make the gesture at the place where he made it, but he was facing potentially both the judge and the prosecutor and made this motion in court, and he was sent to jail for 90 days. So he has a long, interesting history. More things you never want to do. Okay, this is from July of this year. A suit was filed against Knox Rickson and four of its attorneys. They allegedly conspired. This is a completely different case now, to hire hackers to hack into law firms with workers' comp cases. We've already established, you all agree, they can't do this. The reason they got caught is because they showed up in court and they had the intake file for the client on the other side. And they apparently showed it. And the judge went, wait a minute, where did you get this from? And if you guys are maybe too young to know Jackie Gleason, they started going humming, looking at each other. They couldn't come up with how they'd gotten that file. They had no idea. That's what they told the court. They had no idea how they got that file. But then there was some investigation done. Don't know yet what's going to happen again. This is one that's been filed. All of these are allegations. But when you show up with the other side's client intake file in court, you can't explain how you got it. You have an ethics problem, at least potentially.
So, this guy, and we're back in Illinois now. Slide down. Yeah, slide it down. Yeah, all right. Now that we can see the actual slide. That this has been going on for a lot of years. Friend of Law is one of the law firms that are out there filing these John Doe lawsuits. And I don't know if you know or have read about any of these things going on. Basically what happens here is that they file John Doe lawsuits, they try to get the court to give them authority to go to the ISPs to reveal the identity or the subscriber of a particular IP address that they claim has downloaded pornographic movies as a copyright violation. So, and they're on the BitTorrent network doing all this stuff. He happens to be one of the lawyers that's there. Apparently, Illinois found that he's filing these lawsuits with absolutely no intent of filing a lawsuit. It's basically a scare tactic. So now once you've got the John Doe identifier, then they send them out a letter saying, pay me this money and then to settle this case. And that's approximately what it is. And most of these folks that are getting these they don't have the money to fight against it. I've been personally involved in many of these cases revolving around this. A judge, as Sharon said, remember before, the judge's attorney, the judge is the one that turned it into the disciplinary board, but it's a form of extortion. So people are saying, you know what, I'll pay $3,000. It's going to cost me more for a lawyer to do it. I'm not fighting it. I didn't do it, but so what? So that's kind of where that one is. The latest thing they heard on this particular group of attorneys and how they're going after folks is one lawyer who's involved in a case with said, you know, it was a great idea. They're claiming he downloaded this stuff and they want to do an examination of his computer. Well, he's got a friend that's from the Middle East And he came out, really, really good friend. He came out and visited him.
Oh, he was living from living.
Yeah, and he stayed, several weeks with him, and he loves this kind of stuff. It's because they're pornographic films. So he says, it must have been him downloading it, because it wasn't me. And he's such a good friend that I gave him the laptop to take back. So they dropped the case. I thought it was a little too expensive to send somebody
They
in.
dropped
Yeah.
the case. That was the most ingenious thing I've ever heard. Bore no relation to reality, but it worked.
Well, we don't know. We don't know if it was
Well,
reality.
we don't know for sure.
Yeah, if it
I'm
was
pretty
real.
sure the lawyer who was telling it didn't think it was a real story.